Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the IBC and also to navigate through the intricacies of the proceedings under the Insolvency and Bankruptcy Code 2016. So friends, let us discuss one very important case today. So this is the case of Anjani Kumar Prashar versus Manab, Datta and others, which was decided on the 14th of March 2024 by the Honorable NCLAT. So the recent decision by the Honorable NCLAT in New Delhi has significant implications regarding the interplay between the CIRP and proceedings under the SARFAESI Act 2002. The Honorable NCLAT in Anjani Kumar Prashar, who is the suspended director of Grand Star Realty Private Limited, versus Manab, Datta and others, upheld an order of the NCLT New Delhi bench dated 26th of September 2023, which is the impugned order, admitting a petition filed under Section 7 of the IBC 2016 by real estate allottees against a successful auction purchaser who took over a real estate project from the original developer in auction proceedings under the SARFAESI Act 2002. Now, let us see the factual background of the case. In 2012, ICMAI Projects Limited, which is the original developer, purchased an extent of land situated in Haryana from Subros Limited by way of a registered sale deed with a license to develop the land. Now, ICMAI entered into a builder's buyer's agreement with various real estate allottees for construction of flats, under the terms of which the flats were to be delivered to the allottees within 3 years with a grace period of 6 months. ICMAI obtained a loan from Yes Bank Limited, and pursuant to a default by ICMAI, the bank instituted proceedings under SARFAESI and issued an auction sale notice for sale of the property in 2016. Subsequent to the sale notice, Grand Star Realty Private Limited, which is the appellant, was declared as the successful auction bidder and issued a sales certificate and a sale confirmation advice in its favor by the bank. Now, Grand Star Realty Private Limited, which is the corporate debtor and the appellant, participated in the auction and secured the assets with a bid of rupees 40.75 crores. Despite challenges through a writ petition, the Delhi High Court directed to maintain the status quo in favor of the corporate debtor. Subsequently, home allottees initiated CIRP against the corporate debtor for defaulting on a debt of rupees 78.09 crores. Further to this, an analysis of the sale certificate and sale confirmation advice issued in its favor by the bank ensued. Now, the sale certificate or the sale confirmation advice issued in favor of the appellant clearly recorded that the secured assets, being the flats in question, had been sold to the appellant on an as-is whereas and as-is what is basis, and the appellant would be liable to honor all lawful allotments in favor of the allottees and abide by the terms of the existing arrangements between the allottees, the bank, and ICMAI, that the rights of the allottees would not undergo any change on account of the auction process, and the appellant was entitled to receive unpaid portion of consideration from the flat allottees. Now, both ICMAI and the appellant sought to challenge the sale certificates by way of separate proceedings before the Delhi High Court and the Debt Recovery Tribunal respectively, which were dismissed. In the meantime, CIRP proceedings were initiated against ICMAI, and the allottees in the project also filed their claims against ICMAI. Separately, in 2020, the allottees in the project also filed an application under Section 7 of the IBC, seeking initiation of CIRP against the successful auction purchaser, which is the appellant. Now, by way of the impugned order, the Honorable NCLT allowed the application and admitted the CIRP against the appellant, which was challenged by the appellant before the Honorable NCLAT. Now, what was the issues considered by the Honorable NCLAT? Now, the NCLAT in the instant case formulated two issues for consideration, which included whether the appellant, being the successful auction purchaser of the said land under SURFACE, is a financial debtor of the allottees in the project who executed the builder's buyer's agreement with ACME, that is its predecessor. The Honorable NCLAT held that the appellant, being the successful auction purchaser, was bound to honor the rights of the allottees under the builder's buyer's agreement with ACME. The Honorable NCLAT noted that the builder-buyer agreements executed by ACME with the allottees expressly provided that the description of ACME under the terms thereof included its successors, executors, administrators, and assigns. The NCLAT further clarified that a financial debt can be owed in more than one manner. And while drawing an analogy to transfer of liabilities pursuant to a merger or an amalgamation, held that in the present case, the appellant, by virtue of having taken over the project from the original developer in the auction proceedings under SURFACE, was clearly a financial debtor, vis-a-vis the allottees or the home buyers under the IBC, and could not seek to escape the proceedings of the IBC and thereby defeat the rights of the allottees or the home buyers. Lastly, the Honorable NCLAT also rejected the appellant's submission that the filing of a claim by the allottees against ACME would preclude them from instituting a fresh petition for initiation of CIRP against the appellant. On this basis, the NCLAT affirmed the impugned order. Now, what are the findings in Rationale? The Honorable NCLAT's decision rested on several key observations. Firstly, it emphasized the importance of honoring lawful allotments and agreements made with the respondents as explicitly outlined in the sale confirmation advice issued to the corporate debtor. The tribunal noted that obligations towards allottees persist and are transferred to the purchaser of the assets, aligning with the definition of a financial creditor under the IBC. Additionally, the NCLAT interpreted the definition of financial creditor expansively, considering that debts can be legally assigned or transferred, as in the present case, where the corporate debtor acquired the assets through the SURFACE Act. It underscored that the corporate debtor fulfills the definition of financial creditor under the Section 5, subsection 7 of the IBC by inheriting the debt owed to the respondents. So, friends, we conclude that the Honorable NCLAT affirmed that CIRP can indeed be initiated against the auction purchaser in proceedings under the SURFACE Act 2002 under Section 7 of the IBC. The decision underscores the necessity of upholding contractual obligations and ensures the effectiveness of the insolvency resolution framework in safeguarding the rights of the creditors. Now, this landmark ruling provides clarity on the legal landscape governing insolvency proceedings, especially in the real estate cases, and reinforces the principles of fairness and accountability. It serves as a guiding precedent for future cases. So, friends, we see here how the courts are time and again protecting the rights of the home buyers and the allottees under the real estate cases and trying to resolve the issues which are right now in the real estate industry in our country. So thank you, friends, for being with me here today. I trust that you find this both engaging as well as enlightening. So for further insights into such key judgments under the IBC, please like this video and subscribe to my YouTube channel. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.